Hello students, in this lecture I am revising various limits in corporate laws. At CA Inter level we are having 12 chapters in corporate laws, 11 from Companies Act and 1 is LLP Act. In all these 12 chapters you will find various limits, time limits, amount limits. I compiled all those limits into a single document. Now I am revising all those limits in this video lecture. Here comes our first chapter, preliminary. That first one is associate company. In the definition of associate company, the term significant influence means control of at least 20% of total voting power. As we all know, voting power comes from equity share capital. So, suppose there are two companies, C Limited, A Limited. C Limited is having 10,000 equity shares. I assume all the equity shares are with normal rights. That means each and every share carries equal voting rights. Now A Limited is holding 2000 shares in C Limited. In terms of percentage, A Limited is holding 20% of equity share capital of C Limited. That means A Limited is holding 20% of equity share capital means A Limited is having 20% total voting power of C Limited. Now C Limited is an associate company to A Limited. Here at least 20% also covers 20%. Even it is 20%, yes, the condition significant influence is said to be satisfied and the company becomes associate company. Next point, government company. Any company in which not less than 51%, that means greater than or equal to 51% of paid up share capital is held by central government, one or more state government or state governments, or partly by central government and partly by one or more state government or state governments, and subsidiary to a government company is also a government company. Same example, C Limited. C Limited is having 10,000 equity shares. Out of 10,000 equity shares, central government is holding 5,100 equity shares. In terms of percentage, 51% of paid up share capital. Now C Limited becomes government company. Suppose central government is holding 5,099 shares out of 10,000 shares. How many shares? 5,099 shares. In terms of percentage, it is 50.99%. Now can we call C Limited as government company? The answer is no. Why? The main condition is at least 51%. That means equal to 51% or greater than 51%. Any percentage less than 51, then that company is not treated as government company. Is it clear? Next one, small company. Important definition. Small company means a company other than a public company. That means it should be a private company. And its paid up share capital shall not exceed 4 crores. So paid up share capital is less than or equal to 4 crores. And turnover of which as per profit and loss account for the immediately preceding financial year is less than or equal to 40 crores. So both the limits 4 crores and 40 crores are also covered in the definition of small company. In examination, to confuse you, they will frame a question like this. See private limited company, a private limited company. It is having a paid up share capital of 3 crores and its turnover is 40 crores. Now in examination, you will get a confusion. So the confusion is whether 40 crores limit is covered in the definition of small company or not. Whether it is less than 40 crores or less than or equal to 40 crores. Understood? So the answer is 40 crores is also covered within the definition of small company. Turnover 40 crores. Yes, condition is satisfied. Paid up share capital, it is within the limit of 4 crores only. So condition already satisfied. And it is a private limited company. So this is a small company. Understood? So they will exactly ask you the limit. Exactly they will ask you, they will frame a question with same limit, equal limit. Clear? And one more question, in one attempt this question was asked. C Private Limited, as on 31st March 2024, the paid up share capital is 3 crores, turnover is 50 crores. Now what is the status of company for financial year 2024-25? So answer is not a small company. Why? Turnover already exceeded the limit of 40 crores. Turnover already exceeded the limit of 40 crores, so not a small company. Now as on 31st March 2025, the paid up share capital of the company is 3 crores and turnover is 30 crores. So what is the status of a company for financial year 2025-26? Is there any change in status of the company? Now the answer is yes, it is a small company. So don't think like this, once small company status is lost, it will be lost forever. No. Every year you have to check the limits. Every financial year you have to check the limits of preceding financial year financial statements. If the limits are, if the amounts are within the limits, then for the current financial year, it is a small company. Any limit exceeded, then it is not a small company. Understood? Everyone. So, sir, next year, suppose two amounts, paid up share capital, turnover, they are within the limits, sir. In that case, for the next financial year, the company is treated as small company only. Clear? Okay. Next one, subsidiary company. Here in the subsidiary company, the limit is exercises or controls more than one half of the total voting power. More than one half. That means greater than 50%. Suppose company C Limited is there. Company C Limited. The total equity share capital of the company, 10,000 shares. 10,000 shares. A Limited is holding exactly 5,000 shares in C Limited. How many shares? 5,000. In terms of percentage, it is 50%. Now, can we call C Limited as subsidiary to A Limited? No, C Limited is not a subsidiary. The limit here is more than 50%, more than half. Then what is the C Limited to A Limited? What is the relation between C Limited and A Limited, sir? C Limited is an associate company to A Limited. Just check the first definition, first point, significant influence, at least to 20%, I told you, right? So 50% is also covered in the limit of at least 20%. Are you all getting my point? Instead of 5,000 shares, suppose A Limited is holding 5,001 shares in C Limited. Now in terms of percentage, it is 50.01%. So 50.01% means greater than 50% only. Now C Limited is a subsidiary to A Limited. Clear? In government company, the limit is greater than or equal to 51%. Subsidiary company, the limit is greater than 50%. Associate company, the limit is greater than or equal to 20%. Clear? Next one, incorporation of a company. One person company. Incorporation of company. In that first one is one person company. Follow me carefully. In one person company, you will find two persons. One is member and the other one is nominee. Member and nominee should satisfy three conditions. First of all, he should be a natural person, Indian citizen and Indian resident. Now for checking the residential status, how can we check residential status, sir? Very simple. Check the period of stay in India. If the period of stay in India is greater than or equal to 120 days in the preceding financial year, if his period of stay in India is greater than or equal to 120 days, then he is eligible person to become member of OPC or to become nominee of OPC. Understood? The limit is greater than or equal to 120 days in the preceding financial year. Next one, the same concept. In OPC, you will find two persons, member. The other one is nominee. Before naming someone as nominee, member should obtain written consent from the nominee. And nominee is having an option to withdraw the written consent. Member is having an option to remove nominee. Or in the event of death of the member, nominee becomes member of the OPC. In all these three situations, there arises a vacancy in nominee. Position. So now, within 15 days of vacancy of nominee position, a new person shall be named as nominee. Within 15 days, a new person shall be named as nominee, and within 30 days, the same shall be communicated with ROC. Appointment of new person as a nominee, the same, within 30 days, the same shall be communicated with ROC. So here we need to provide the details of vacancy in the nominee position, and we appointed a new person as a nominee of one person company. Understood? So two time limits. One is 15 days, appoint new person as nominee. Next one, within 30 days of vacancy in nominee position, communicate the same with registrar. Next one, reservation of name. As you all know, first step for incorporation of company is reserving the name. Yes or no? So in case of newly incorporating companies, new companies, proposed companies, the name is reserved for a period of 20 days from the date of approval. So the name is reserved for a period of 20 days in case of new companies. Sir, I'm existing company, sir, I want to change my name. In that case, the name shall be reserved for a period of 60 days from the date of approval. So new company, 20 days is the reservation period. Existing company which is planning to change the name, so 60 days is the reservation period, 60 days from the date of approval. Next one, situation clause. Situation clause. Every company after incorporation within 30 days, that means day 30. Day 1 is date of incorporation, day 30. That means within 30 days of incorporation, a company shall have registered office. Company shall open registered office. And within the same time limit, there is no change in time limit. Within the same time limit, company has to furnish the details of registered office to the ROC, Registrar of Companies. So here you will find two limits, 30 days, 30 days. It's not 30 plus 30. It is not 30 plus 30. It is single 30. Within 30 days of incorporation, company shall open registered office, and within 30 days of incorporation only, company shall furnish the details of registered office to the Registrar of Companies. Understood? Just check the time limits. And in case of IFSC companies, the time limit is 60 days. It's not 30 days, it is 60 days. Next one, provision for entrenchment. See, entrenchment means placing additional restrictions for altering articles of association. Generally, for altering articles of association, special resolution is sufficient. But certain clauses of AOA can be altered by passing a resolution which is more powerful than special resolution. For example, unanimous resolution. So if you want to place entrenchment provisions, if you want to entrench articles of association, you need to take consent from the members. After getting consent from the members, the same shall be communicated with the Registrar of Companies. And the time limit for communicating entrenchment provisions with Registrar of Companies is 30 days. So day 1 you made entrenchment, you inserted entrenchment provisions in the articles of association. Within 30 days, that means by day 30, yes, company has to file an intimation. Company shall intimate Registrar of Companies. Next one, copies of MOA, AOA, etc. to be given to the members. See, being a member of company, he can request a company for following documents. Yes, I need MOA, I need AOA, I need resolution copies, or I need agreements entered by the company which were filed with Registrar of Companies. So a member can request company to provide the following documents. Here request alone is not sufficient. Along with request, member has to deposit sufficient money. He has to deposit sufficient money. So after these two conditions get satisfied, a company within 7 days of written request and receipt of money, company has to furnish the information to the requested member. So here the time limit is within 7 days of the request made by him, company shall provide the following information to the members or requested member. Next one, rectification of name of company. Now I incorporated one company, the name of company is similar to the name of existing registered trademark, or the name of company is similar to the name of existing body corporate. In that case, central government is having a power to issue an order for rectifying the name of company. And the time limits, here you will find 3 time limits. First one, owner of registered trademark has to file an application with central government regarding infringement of trademark, and this application shall be filed within 3 years. Within 3 years from date of incorporation of company. When company got incorporated, from the date 3 years time is given to the owner of registered trademark to file an application with central government regarding infringement of trademark. Now central government will issue an order to the company, yes, come on, rectify your name. Company has to comply this order within 3 months. Within 3 months from the date of order, company has to comply the direction of central government. You all getting my point, students? Next one. And company, after changing its name, obtains a new name, shall give notice of change to the registrar along with the order of central government. Power already delegated to regional director. Okay. So within a period of 15 days from the date of such change. So once company changes its name, it has to communicate the same with the registrar within a period of 15 days from the date of change. A registrar will register the same and will issue fresh certificate of incorporation. So 3 time limits. One, the time limit for filing an application by registered trademark. The time limit is 3 years of incorporation of company. Next one, company has to comply the directions of central government within a period of 3 months. Next one, company after changing the name, it has to intimate a ROC within 15 days of change. Next point, alteration of object clause. The registrar shall register any alteration of memorandum with respect to objects of the company and certify the registration within a period of 30 days. So registrar has to issue a certificate regarding alteration of object clause of the memorandum of association within a period of 30 days from date of filing the special resolution. Today registrar received an application from the company regarding change of objects. Along with application, yes, copy of special resolution also filed by the company. Yes, it is also received by the registrar. Now from the date of receipt of these documents within 30 days, yes, a registrar shall issue a certificate of registration of alteration of objects. Next one, alteration of articles. Every alteration of articles shall be filed with registrar within a period of 15 days from the change. Whenever you change articles, within 15 days you have to file a copy of altered articles with a registrar. In case of conversion of companies, particularly public company to private company, you are a public company, you want to convert your company into private company. In that case, within 60 days from the date of passing special resolution, within 60 days from date of passing special resolution, the company has to file an application with central government. Central government approval is compulsory for conversion of public company into private company. And what is the time limit? 60 days from the date of passing special resolution. Next one, commencement of business. Commencement of business. Company with share capital incorporated on or after 2nd November 2018. Not all companies, companies with share capital incorporated. The date is 2nd November 2018. These companies have to file a declaration with registrar of companies. This declaration is all about commencement of business and the applicable form is INC 20A. The time limit is 180 days of date of incorporation. Within 180 days of date of incorporation, company has to file a declaration with ROC. Form number INC 20A. Time limit is 180 days. So with this, incorporation of companies also completed. The next chapter is prospectus and allotment of securities. So prospectus validity period. Generally, prospectus will have a validity period of 90 days from the date on which a copy thereof is delivered to registrar. So what is the validity period of prospectus? 90 days from the date of delivery to the registrar. As you all know, before publishing prospectus, every company has to file a copy of prospectus with registrar. So from the date of filing, the prospectus generally will have a 90 days validity period. It's not 90 days from date of publication. It's 90 days from date of delivery to the registrar. Understood? After expiry of 90 days, the prospectus will lose its validity period. But there is one exception to this general rule. The exception is shelf prospectus. In case of shelf prospectus, the validity period is 1 year. And this validity period 1 year will start from date of opening of first offer of securities. It's not date of delivery to the registrar. It is date of opening of first offer of securities. When you opened first offer of securities under shelf prospectus, from that date onwards, shelf prospectus will have a validity period of 1 year. And in shelf prospectus, there is one more time limit. The time limit is whenever company receives advance applications, advance money in case of shelf prospectus, It is the duty of company to provide information memorandum to those applicants. And company must give withdrawal option to the applicants. If applicants decide to continue with the company, then company can make allotment of securities to those applicants. If applicants desire to withdraw their application, then company shall refund all the monies received as subscription within 15 days from exercising that option. Within 15 days of exercise of option, company has to refund all the advance application monies, all the monies which company received in advance. Next one, a company proposing to issue a red herring prospectus shall file it with registrar at least 3 days. So at least 3 days. I'll change some small errors. I'll change it and I'll upload the document along with video. Don't worry. So here the time limit is at least 3 days prior to the opening of subscription list and the offer. In case of general prospectus, on or before publication, it has to file a copy of prospectus with registrar. But coming to red herring prospectus, at least 3 days prior to opening of subscription list. It's not date of publication. It's not date of publication. It is 3 days prior to opening of the subscription list and offer. So the time limit is 3 days prior to the opening of offer. Next one, return of application money. For making allotment of securities, company has to satisfy two conditions. One is minimum subscription and the other one is minimum application money. And company has to satisfy these two conditions within a period of 30 days from the date of issue of prospectus. So here the time limit is within 30 days from date of issue of prospectus, company has to satisfy minimum subscription condition and minimum application money condition. If not satisfied, then the application money shall be returned within a period of 15 days from closure of issue. 15 days from closure of issue, not 15 days from date of prospectus, not date of issue of prospectus. So in prospectus, you will mention offer period. So closure of offer period. So what is the closure date? From that date onwards, within 15 days, you have to refund all the application monies. Failed, then directors and officers who are responsible for default shall be jointly and severally liable to repay money along with interest at the rate of 15% per annum. It is not company who is paying the interest. Who is paying the interest? Directors, officers who are in default. Simply defaulting officers are responsible to repay money along with interest. What is the rate of interest? 15% per annum. Next one, return of allotment. Suppose company made allotment of securities under prospectus. Company made a public offer and company satisfied two conditions, minimum subscription, minimum application, and company proceeded with allotment of securities. In that case, within 30 days of allotment, company has to file a return of allotment with a registrar in form PAS3. So day 1, for example, allotment was made on day 1. Now within 30 days, by day 30, company has to file return of allotment with registrar. Next one, private placement. See, all companies can offer its securities under private placement. Public company or private company can offer its securities under private placement. But in private placement, there is a restriction. The restriction is it can offer securities to the members not exceeding 200. That means it can offer its securities up to 200 persons in a financial year. And this 200 count is applicable per security. Suppose company C Limited is there. It is having equity shares, preference shares, and it is also having debentures. Now it can make private placement of up to 200 for equity shares, up to 200 in preference shares, up to 200 persons for debentures. That means it can make private placement up to 600 persons in a financial year. So limit of 200 is applicable individually to each and every security. If company is having 4 types of securities, then it can make private placement 200 for first security, 200 for second security, 200 for third security, and 200 for fourth security. Are you all getting my point, students? So count 200 is per financial year and per security. Next one, after receiving application money within 60 days from date of receipt of application money, company has to make allotment. If company fails to make allotment within 60 days, then repayment of application money to the subscriber shall be made within 15 days. Day 1, company received application money. Within 60 days, company has to make allotment. If company fails to make allotment, then within next 15 days, that means total 60 plus 15, that means within 75 days from the date of receipt of application money, company has to refund all those application monies. Failed, then company has to pay interest. Company has to pay interest not from 76th day but from 61st day. In case company makes allotment of securities, then a return of allotment shall be filed with registrar within 15 days from date of allotment. Return of allotment time period is 30 days under prospectus. In case of private placement, the time limit for filing return of allotment is 15 days from date of allotment. What is the time limit? 15 days from the date of allotment. Next one, share capital and debentures. Equity shares with differential rights. So the limit is voting power from differential rights shall not exceed, that means less than or equal to 74% of total voting power of the company. So total voting power means generally what? Total voting power means voting power from equity shares with differential rights plus voting power from equity shares with normal rights. Voting power from equity shares with differential rights, voting power from equity shares with normal rights. So now the limit on differential rights is simply voting power from differential rights less than or equal to 74% of voting power from normal rights plus voting power from differential rights. So this is the equation. Understood? Next one, last 3 financial years, in the current financial year, if company is planning to offer equity shares with differential rights, then preceding 3 financial years, company has not defaulted in filing annual accounts, company has not defaulted in filing annual returns, and company is not penalized by any court or NCLT. Understood? So last 3 years, there should be no default on the company with respect to filing of annual accounts, annual returns, and not penalized by the court or NCLT. Next one, issue of duplicate share certificate or issue of duplicate certificate. So a member lost original certificate, he can apply for duplicate certificate. In that case, there is no time limit for filing application for duplicate certificate. He can file application within a reasonable time. Once company receives application for duplicate certificate, then company has to issue duplicate certificate within the prescribed period. In case of unlisted companies, the prescribed period is 3 months. In case of listed companies, the prescribed period is 15 days. Understood? So 3 months, 15 days, count is from date of application, date of receipt of application from the member. Within 3 months, unlisted company has to issue duplicate certificate. Within 15 days of application, listed companies has to issue duplicate certificate. Next one, variation of shareholders' rights. Variation of shareholders' rights. For changing the rights of shareholders, company has to obtain consent of members or holders of at least 75% of issued shares. Suppose 10,000 shares are there in a company, 10,000 shares are there. 75%, that means, holders of 7,500 shares. Here there is no restriction on number of holders. Suppose one person alone is holding 7,500 shares. Now, if you are able to get consent from that one member, variation is permitted. Understood? Here there is no restriction on number of members. Here the restriction is at least 75% of issued shares. Issued shares 10,000. In that case, you need to get consent from the holders holding at least 7,500 shares in writing. Sir, we can call for a meeting, sir. In that case, get a special resolution in that meeting. Either of these 2 options should be satisfied. One is get consent in writing. In case of written consent, holders of at least 75% of issued shares must give consent for variation, must give consent to the variation. If you are able to call for a meeting, special resolution is required. Next one, holders of at least 10% of the shares No, out of 10,000 shares, 10% means 1,000 shares. Now, persons holding 1,000 shares can file an application with the tribunal in order to cancel that variation. So whatever order passed by the tribunal, whether approving the variation or cancellation of variation, whatever NCLT passes the order, that order copy shall be filed with registrar within 30 days of the date of order. Within 30 days of the date of order, it is the duty of company to file NCLT order with registrar. Next one, limit on issue of sweat equity shares. Limit on issue of sweat equity shares. At a time, a company can issue sweat equity shares up to 15% of existing paid up equity share capital, or rupees 5 crores sweat equity shares paid up share capital, whichever is higher. Understood? At any point of time, a company can issue sweat equity shares to the extent of 15% of existing equity share capital, or rupees 5 crores sweat equity share capital, whichever is higher. But in the entire lifetime of the company, the limit of sweat equity shares shall not exceed 25% of paid up equity share capital of the company. So this year you issued 15%. Suppose my company share capital is 100 crores. This year I issued 15% of paid up equity share capital as a sweat equity shares. Next year I can offer only 10% only. I can offer only 10%. Why? Throughout the lifetime of the company, the limit is 25% of paid up equity share capital of the company. In case of startup companies, this 20 instead of 25%, they can go up to 50%. And this benefit is available only up to 10 years from the date of incorporation or registration. So for startup companies, limit is not 25%, the limit is 50%. Benefit is given up to 10 years from the date of incorporation. Maximum tenure of redeemable preference shares. Company is prohibited from issuing irredeemable preference shares. Company can issue only redeemable preference shares with a tenure not exceeding 20 years. So company can issue preference shares for a tenure up to 20 years. In case companies are involved in infrastructure projects, the time period is not 20 years, the time period is 30 years, subject to a condition that every year at least 10% redemption, at least 10% of preference share capital shall be redeemed. So by the end of the 30th year, you will find 10% and company will redeem the 10% also. So at the end of 30th year, you will find 0%. Understood? Next, transfer and transmission of securities. So this time limit, this is a condition on transferor and transferee. Once transfer deed is executed, within 60 days of execution of transfer deed, yes, it is the duty of transferor or transferee to submit these documents to the company. So time limit is 60 days from the date of execution of a transfer deed or transfer instrument. Next one, time period for delivery of certificates. Time period for delivery of certificates. In case of incorporation, company got incorporated, to the subscribers within a period of 2 months from date of incorporation. To the allottees under prospectus or private placement, to the allottees within a period of 2 months from the date of allotment. In case of transfer, so company has to give share certificate to the transferee within a period of 1 month from date of receipt of transfer instrument or intimation of transmission. In case of allotment of debentures, the allottee of debenture should get a certificate within a period of 6 months from the date of allotment. That means second point, this is restricted to equity shares only, preference shares only. So second point is all about shares. Fourth point is for debentures. Debentures. So time limits 2 months from date of incorporation, 2 months from date of allotment, 1 month from date of receipt of transfer instrument or intimation of transmission, 6 months from the date of allotment of debentures. For IFSC companies, the time limit is 60 days after incorporation, allotment, transfer, transmission. Only one time limit is there. The time limit is 60 days after incorporation, allotment, transfer or transmission. Next one, alteration of capital clause. Within 30 days of alteration, a notice must be given to the registrar of companies in form SH7. So whenever company alters capital clause, it is the duty of company to file SH7 with ROC. What is the applicable time limit? 30 days of alteration. 30 days of alteration. And same is applicable for redemption of preference shares also. Same is applicable to the redemption of preference shares. In case of redemption of preference shares, within 30 days of redemption, company has to file a form with registrar. Next one, issue of further shares. Only two time limits. One is notice. And the other one is offer period. So notice shall be given at least 3 days before opening of the issue. So what is the when the offer gets opened? So before that, at least 3 days before opening the offer, you need to intimate the members about issue of further shares. And the offer period, that means interested persons, whoever wants to file an application for new shares. So the offer period shall be minimum 15 days. Minimum 15 days, maximum 30 days. Minimum duration is 15 days, maximum duration is 30 days. And these time limits, at least 3 days, at least 15 days, these two time limits can be reduced in case of private company with 90% of members' consent. In case of private companies, if you are able to get consent from 90% of the members, not paid up share capital, here the restriction is on members. If 90% of members have give their consent in writing or in electronic mode, then 3 days, 15 days can be reduced. Next one, restriction on purchase by company or giving of loans by it for purchase of its shares. So here, a company can advance money to its employees for purchasing its own shares. But 3 conditions are there. One is employee excludes directors, employee excludes KMP. The maximum loan amount is, here the loan amount is maximum 6 months salary. Suppose employee salary is 30,000, then company can lend him up to 1.8 lakh. 30,000 into 6 months, 1.8 lakh. And with that money, this employee should acquire or should subscribe fully paid shares, not partly paid shares, fully paid shares. So here the limit is loan amount shall not exceed 6 months salary. So up to 6 months salary, no problem, no violation. Next, important limit, buyback. Important limit. So a lot of students get confusion between these 3 points. Just follow me carefully. These first 2 points speak about amount to be spent on buyback. Amount to be spent on buyback. And this third point is all about number of shares, number of securities that a company can buy back. So third point is all about number of shares. First 2 points all about amounts to be spent on buyback. So first I'll tell you the third limit. In case of buyback of equity shares, maximum limit is 25% of total paid up equity share capital. Suppose company is having 10,000 equity shares. 10,000 equity shares. A company can make buyback up to 25%, that means 2,500 shares. In a financial year, it can make buyback up to 2,500 shares. Here the limit is on number of shares. Coming to first 2 points, amount to be spent on buyback. Suppose, for making buyback of these shares, company announced buyback price 25 rupees. Face value is 10 rupees, buyback price is 25 rupees. And let me tell you, paid up equity share capital of the company is 1 lakh, 10,000 into 10 rupees, 1 lakh only, right? Free reserves 1 lakh, securities premium 1 lakh. So total how much? 3 lakhs. Equity share capital 1 lakh, free reserves 1 lakh, securities premium 1 lakh. So total 3 lakhs. Now in this case, if company decides to spend amount on the buyback is 10% of paid up equity share capital plus free reserves plus securities premium. In that case, board approval is sufficient. So 10% of paid up equity share capital plus free reserves plus securities premium. That means in this case, if company want to spend 30,000 on buyback, then board resolution is sufficient. No sir, company is planning to spend more than 30,000 sir. Exceeding 10% of paid up equity share capital sir. Exceeding up to 10%. Board approval. Exceeding 10%, that means greater than 10%, in that case special resolution from members is required. And sir, exceeding 10% means can I spend 50% of paid up share capital plus free reserves plus securities premium? No, no, no. Maximum you can spend 25% only. Maximum you can spend 25% only. That means, special resolution power is, the power of special resolution is greater than 10% of paid up equity share capital plus free reserves plus securities premium, and less than or equal to 25% of paid up share capital plus free reserves plus securities premium. So in this case, in the given example, the limit is like this, greater than 30,000 but less than or equal to 75,000. So amount to be spent on buyback, if it is between 30,000 and 75,000, then special resolution is required. So first 2 points speak about amount to be spent on buyback. Third point speaks about number of shares a company can make buyback. Next, fourth point, buyback shall be completed within a period of 12 months. Within a period of 12 months from date of passing special resolution or board resolution. So special resolution, board resolution will have a validity period of 12 months. Within 12 months, company must complete buyback. And the time gap between two buybacks. Time gap between two buybacks. Buyback 1, buyback 2. So completion of buyback 1 and opening of buyback 2. Opening of buyback 2. So the time gap between these two events should be minimum 12 months. Let me repeat, minimum 12 months. The time gap between two buybacks means buyback, earlier buyback closure date, latest buyback opening date. The time gap between these two events should be minimum 12 months. Once buyback is completed, then company is prohibited from issuing the same kind of shares or same kind of specified securities within a period of 6 months. Today buyback completed, equity shares with normal rates. Company made a buyback of equity shares with normal rates. Now company is prohibited from issuing same class of shares for a period up to 6 months from date of completion of buyback. In one attempt, a question came for 5 marks, interchanging the limits. They interchanged the limits. What they told, the time gap between two buybacks should be 6 months. And once buyback is completed, company is prohibited from issuing same kind of shares for a period of 12 months. Like that, they interchange the limits and they asked question for 5 marks. If you remember these limits, you can answer it properly. If you forget the limits, 5 marks loss. Understood? Next one, once buyback is completed, within 7 days of completion of buyback, company has to extinguish or physically destroy the securities. And once buyback is completed, within 30 days of completion of buyback, company has to intimate registrar. In case of listed companies, company has to intimate registrar as well as SEBI about completion of buyback. Next one, debentures. Debentures. Maximum tenure of secured debentures is 10 years. 10 years. In case of companies engaged in infrastructure projects, infrastructure debt fund NBFCs, infrastructure finance companies, the maximum tenure is 30 years. For preference shares, it is 20 and 30. For debentures, it is 10 and 30. Clear? And debenture redemption reserve, all unlisted companies other than all India financial institutions and other than banking companies, they have to create debenture redemption reserve which is equal to 10% of outstanding debenture. Minimum 10% of outstanding debenture. Next one, deposits. In exempted deposits, you will find only two categories with limits. Two categories. One is security deposit from employee. Security deposit from employee will not be considered as deposit if that security deposit is up to 12 months salary. Up to 12 months salary. Exceeding 12 months salary, then it is a deposit. Then it is a deposit. And this deposit should be a non-interest bearing security deposit. That means, company should not pay any interest on that security deposit. If these two conditions are satisfied, then it is not a deposit. Next one, amount of 25 lakh rupees or more. 25 lakh rupees or more received by a startup company by way of convertible note in a single tranche from a person, then also it is not a deposit. But this benefit is up to 10 years from date of issue. Understood? Convertible. These amounts, these deposits should be converted into equity shares within a period of not exceeding 10 years from the date of issue. Eligible companies, only public companies comes under the category of eligible company. So public company with a net worth 100 crores or more, not more than 100 crores. It is not greater than 100 crores. It is greater than or equal to 100 crores. Or public company with a turnover 500 crores or more. Any one condition satisfied, then it is a eligible company. Public company with net worth 100 crores or more, public company with turnover 500 crores or more, it is an eligible company. Eligible company can accept deposits from both members as well as non-members. Next one, ordinary resolution is sufficient if an eligible company is accepting deposits within the limits. So what is this section 180 subsection 1 clause C, sir? See ma, outstanding debt plus proposed debt, outstanding debt plus proposed debt, if it is within the limits of 100% of paid up share capital plus free reserves plus securities premium, in that case ordinary resolution is sufficient. In case, because of accepting these deposits, suppose company is planning to accept 30 crores deposits, accepting these deposits, the limit is exceeding 100% of paid up share capital, sir. Outstanding debt plus this 30 crores, these put together exceeding 100% of paid up share capital plus free reserves plus securities premium, in that case special resolution is compulsory. So up to 100% ordinary resolution, exceeding 100% special resolution. Validity of circular. In prospectus chapter, in public offer you will find prospectus. Coming to the deposits, you will find a document called circular, and this circular is having a limited validity period. The validity period is 6 months from the closure of financial year or the date on which financial statements are laid before the company at AGM. As you all know, the due date of AGM is within 6 months from the closure of financial year only, yes or no? And the time gap between two AGM shall not exceed 15 months. So forget about the second limit. Let's speak about only first limit. So what is the actual due date? Due date of AGM, 6 months from the closure of financial year only. So technically both are same. So 31st March 2024 is the financial year closure date. In that case, the validity of circular is 6 months from closure of financial year. That means 30th September 2024 or date of AGM where company had laid financial statements. Suppose actual date of AGM is 31st July 2024. Whichever is earliest means 31st July 2024. So circular is valid up to 31st July 2024. In case no AGM has been held, the latest day on which AGM should have been held means due date of AGM only. Due date of AGM. That means if the second time period is not available, then what is the due date of AGM, sir? Due date of AGM is 6 months from the closure of financial year, sir. Then 30th September 2024. So 30th September 2024, whichever is earliest means 30th September 2024 only. Next, deposit repayment reserve account. So every year, company has to repay some deposits. See, maximum a company can accept deposits for a tenure up to 36 months. So next year, company is required to redeem deposits. So what is the amount of repayment of deposit? What is the amount? On that amount, apply this 20%. So 20% of the deposits maturing following financial year, not current financial year, following financial year. So what is the amount of deposit maturing in the following financial year? On that, apply 20%. That amount shall be deposited in a scheduled bank, separate bank account. A bank account which is not within the control of company. Separate bank account to be called deposit repayment reserve account. So what is the applicable limit? 20%. 20% of the amounts deposit maturing current financial year or following financial year? Following financial year. Next, tenure of deposits. Tenure. Minimum 6 months from date of acceptance. Maximum 36 months. In latest MTP, I saw one question, company is planning to repay its deposits after 58 months. Like that question is there. Multiple choice question. I saw that question. I read that question. So is it possible? No, not possible. Maximum period is 36 months from date of acceptance. Sir, can I reduce this 6 months? Yes. You can accept deposits for a period not less than 3 months. So maximum 3 months, sorry, minimum 3 months. You can't reduce, below 3 months. Actually, general rule is 6 months. In exceptional cases, you can accept deposits for a tenure of 3 months. And if you are accepting deposits for 3 months, that amount is maximum. That means less than or equal to 10% of paid up share capital plus free reserves plus securities premium. First of all, to what extent a company can accept deposits, sir? Maximum amount of deposits. Yes, I gave a separate table for maximum amount of deposits. You can see here, companies, 4 categories. Private companies, IFSC, public companies. They can accept deposits up to 100%. Outstanding deposits plus proposed deposits. Proposed deposits. Both put together, they can be up to 100% of paid up share capital plus free reserves plus securities premium. Sir, ineligible public company up to 35%. Outstanding plus proposed, up to 35%. Eligible public company, from members it can accept up to 10%. From non-members it can accept up to 25%. Sir, can company increase like this, 11% here, 24%? Can company do like that? No. Changing the limits is not possible. Up to 10 in case of members, up to 25 in case of non-members. Eligible government company, it can accept deposit amounts of 35% either from members or from non-members. So there is no segregation, there is no categorization. Suppose it can accept 5% from members, 30% from non-members, or it can accept 35% from members, 0% from non-members, or it can accept 0% from members, 35% from non-members. Understood? The benefit is available only to government companies. Next, the above mentioned limits are not applicable to the below companies. Private company which is a startup, for 10 years from date of incorporation, it can accept deposits without any limits. It can accept 1000%, 5000% of paid up share capital plus free reserves plus securities premium. There is no limit in case of private company which is a startup, and this benefit is for 10 years from date of incorporation. Next, a private company which is satisfying all these 3 conditions can accept deposits even without any limits. Sir, what are those 3 conditions? Neither an associate nor subsidiary of other companies. Total borrowings less than 2 times of paid up share capital or 50 crores, whichever is less. So total borrowings shall be less than 2 times of paid up share capital or 50 crores, whichever is less, and such company has not defaulted in repayment of such borrowings. Then those private companies can accept deposits even without any limits. It can go beyond 100%, beyond 1000%, beyond 10,000%, no limit. Next, issue of deposit receipt. Within period of 21 days from date of receipt of deposit money, company has to issue deposit receipt. The time limit is 21 days. And after issuing deposit receipt, within 7 days, company has to update deposit register. So for issue of deposit receipt, the time period is 21 days from receipt of money, and updation in the registers is within 7 days from date of issuance of receipt. And that register shall be preserved for a period not less than 8 years in which the latest entry is made in the register. So when you updated that register, from that date onwards up to 8 years, you need to preserve that register. Understood? So preservation period of registers is 8 years from the latest entry in that register. Next charges, only 2 time limits are there. Only 2 time limits. One is registration of creation of charge, registration of modification of charge. And the next one is registration of satisfaction of charge. The time limits is normal time limit. Normal time limit is 30 days from creation, 30 days of creation or modification. Within 30 days of creation or modification. Additional time limit is next 30 days. That means, total 60 days of creation or modification failed. In that case, additional time limit, further period. Understood? Further period. So additional time limit, it is 120 days of creation or modification. Understood? So if you read that provision, first 30 days you will find first 30 days. Next 60 days of such creation. So that means this 60 is including this 30. It's not 30 plus 60 90. It is 60 including above 30. And next one, further period of further additional time limit. Further period of 60 days after payment of prescribed ad valorem fees. So total you will find 120 days of creation or modification. Normal time limit 30 days. With additional fees, you will be given extra 30 days. With ad valorem fees, you will be given extra 60 days. So total how much? 120 days. In case of satisfaction of charge, the time limit is very simple. Normal limit is 30 days. Additional limit is 300 days of satisfaction of charge. 300 days of satisfaction of charge. It is not 30 plus 300. It is not 30 plus 300. It is 30 plus 270 equal to 300. 30 plus 270 equal to 200. That means additional time limit, further time limit is just 270 days. Just read the provision one more time. Some students will read only, 30 days, 300 days. Are 30 days from what? 300 days from which event? So 30 days from satisfaction, 300 days from satisfaction. So additional time limit how much? 270 days. 270 days. Are you all getting my point, students? So charges also completed. Next, management and administration. Management and administration. What is the time limit for updation of register of members, register of other security holders? The time limit is 7 days of date of approval. Within 7 days of date of approval, register shall be updated. Next one, in case of listed companies, if promoters create any pledge on the securities, on their holdings. Understood? Now all those details shall be entered in the register within 15 days from such event. Within 15 days from such event. In the event of pledge or hypothecation charge lien, created by the promoters of any listed company, so those details shall be entered in the register within 15 days from such event. Next one, if company opens any foreign register, outside India, then same shall be communicated with ROC within 30 days. So within 30 days of opening a foreign register, within 30 days from date of opening of any foreign register, company has to give intimation to the registrar. Next one, declaration in respect of beneficial interest in any share. Here you will find total 4 parties: a registered owner, beneficial owner, company, ROC. Registered owner, he is having a, shares were registered in the name of Mr. A, but he is not having any beneficial interest. He is not having any beneficial interest. Beneficial interest lies with B. So B is the beneficial owner, he is not registered owner. Now, within 30 days of getting those shares in the name of A, and within 30 days of getting beneficial interest in those shares, from A point of view, when the shares got registered in his name, from that date onwards, within 30 days, within 30 days. From B point of view, when he got beneficial interest without legal interest, from that date onwards, within 30 days, has to intimate company, has to file a declaration with company. Now company, after receiving these 2 declarations, company has to file a declaration with ROC within 30 days. So here you will find 3 time limits, actually 3 time limits. 30 days from getting registered shares in his name without beneficial interest, 30 days from acquiring beneficial interest, next one 30 days from receipt of information by the company. MGT4, MGT5, MGT6, these things already you know. MGT4 by registered owner, MGT5 by beneficial owner, MGT6 by company. So the time limit is 30, 30, 30. Next one, significant beneficial owners. The difference between beneficial owner and significant beneficial owner is interest percentage. 1% interest is there, beneficial owner. 10% interest is there, sir. 10% interest is there. Then you will be called significant beneficial owner. So details of significant beneficial owners shall be given to the company within 90 days from commencement of this provision. Within 90 days from commencement of the provision. Sir, provision already came into the picture. After commencement of provision only, I got significant beneficial ownership. In that case, within 30 days of acquisition, you need to communicate with company about the details. Once company receives that information, it has to communicate the same with registrar within 30 days of its receipt from SBO. Clear? Time limit 30 days is common in all sections. Okay. Next one. Power to close register of members, register of debenture holders, register of other security holders. Whenever company declares a dividend or whenever company decides to issue further shares or issue bonus shares, first it will identify the eligible persons. In a company, members keep on changes. Member by transferring shares, you will find that, members keep on changes. Today I may be the member. Tomorrow I may not be the member because today night I will transfer my shares to my neighbor. So tomorrow I am not the member. My neighbor will be the member. Now, who is the eligible person to get dividend? Who is the eligible person to get a bonus shares? So for identifying eligible persons, temporarily companies will close registers. That means company will not update register during the closure period. And the closure period can be maximum 30 days at one point of time. At any point of time, maximum 30 days. And throughout the year, it shall not exceed 45 days. Suppose, company, it is closing registers 5 times in a year. Each time it shall not exceed 30 days. And all 5 times put together shall not exceed 45 days. Before closing registers, company has to give notice to its members. And that notice shall be given at least 7 days before closure of registers. Next one, annual return. Every company has to file annual return with ROC. And what is the time limit for filing annual return with ROC? 60 days from AGM. So what is the date of AGM plus 60 days? So that is the normal time limit for filing annual returns. Suppose AGM is not conducted, sir. Then what is the due date of AGM? So due date of AGM, add 60 days. So that is the due date for filing annual returns. Next one, certification of annual return. This is not applicable to all companies. This is applicable only to 3 companies. A listed company, company having paid up share capital 10 crores or more, company having turnover 50 crores or more. To these 3 companies, annual return should get certified by the company secretary in practice. Next, place of keeping these registers and annual returns. First option, registered office. Without any other alternative, first option is registered office. Next option, any place in India subject to 2 conditions. One is special resolution. You need to get special resolution from the members. And the other condition is in that place, in that area or city, town, 1/10, at least 1/10, more than 1/10 of total number of members entered in the register of members should reside. More than 1/10 of total number of members. So here the limit is more than 1/10 of total number of members entered in the register must reside in that place. Next one, preservation of register of members, etc. and annual return. So how long we should preserve the registers? In case of register of members, the time period is permanent. Till the liquidation, company has to maintain register of members. Register of debenture holders, register of security holders, 8 years from the date of redemption. 8 years from the date of redemption. In case of annual returns, 8 years from the date of filing with ROC. Foreign register of members, if it is members register, it is permanent till liquidation. Other than members, debenture holders, other security holders, then 8 years from the date of redemption of such debentures or securities. Next one, notice of meeting. So general meeting can be called by giving a notice of at least 21 clear days. Here clear days means you have to exclude date of posting the notice and date of general meeting. In case of section 8 companies, the time limit is 14 clear days. Sir, can a company call a general meeting by issuing a shorter notice? That means, less than 21 clear days or less than 14 clear days in case of section 8 company. Possible, subject to conditions. If it is annual general meeting, the company has to get at least 95% of members' consent. at least 95%. That means greater than or equal to 95% of members entitled to vote at the general meeting must give consent before the general meeting, or else general meeting notice of general meeting is invalid. If it is EGM by company with share capital, then two conditions to be satisfied. One is majority in number of members. That means more than half of number of members who are representing at least 95% of paid up share capital of the company. In terms of number of members, more than half. In terms of paid up share capital, at least 95% of paid up share capital of the company, as giving a right to vote at the meeting. If these two conditions are satisfied, then EGM by company with share capital can conduct company with share capital can conduct EGM with shorter notice. If it is a company without share capital calling for EGM with shorter notice, then at least 95% of total voting power holders holding at least 95% of total voting power must give consent to that shorter notice. Understood? If it is AGM, forget about company with share capital or without share capital, 95% of members. EGM, company with share capital, two conditions, more than half of the members representing at least 95% of capital. Next one, if it is EGM by company without share capital, just ignore number of members, only one condition, that is 95% of total voting power. Next to quorum, very simple. Private limited company, 2 members personally present. Public limited company, 5, 15, 30. Wrong. You need to remember one more point, that is amount, number mentioned in AOA. Suppose in a public limited company, there are 10,000 members. As per Act, applicable quorum is 30. But in AOA of that company, the quorum is 100. They mentioned the quorum is 100. In that case, 100 or 30, whichever is higher means 100. Understood? Members personally present excludes proxy. Only the members who personally present shall be counted for the purpose of quorum. So limits are 2, 5, 15, 30. 5 in case of up to 1000 members, 15 in case of 1001 to 5000 members, 30 members in case of 5000 above. That means 5001 and above. Next one, proxy. Proxy means representative. One person can represent maximum 20 persons, 20 members, and he can represent maximum 10% of total share capital. Two conditions to be satisfied. So simply I can tell like this, 50 persons, one person can represent 50 members or members holding 10% of total share capital, whichever is less. Suppose each and every member is holding 1% of total share capital. Now a single person can represent, a proxy can represent maximum 10 persons. Why? 10 persons holding together 10% of total share capital. You can't apply 50 in that case. In terms of number of members, 50. In terms of total share capital, 10% of total share capital, whichever is less. Next one, proxy form is valid only if it is received by the company at least 48 hours before the meeting. Next one, if anyone wants to inspect proxy form, he should give intimation to the company at least 3 days before general meeting. 3 days before general meeting. And inspection time period is 24 hours before the commencement of the meeting, and it ends with the meeting. Inspection will ends with the conclusion of general meeting. So simply the time limits are like this with respect to proxy. This is for example AGM. 3 days before AGM, you can give notice of inspection. Deposit of proxy, 48 hours. For deposit of proxy, the time limit is at least 48 hours before commencement of the meeting. Inspection of proxy, 24 hours before general meeting. This is inspection. Inspection can be carried during the period before 24 hours before commencement of general meeting, ends with conclusion of general meeting. Demand for poll. So who can demand for poll? Members as well as proxy. Members as well as proxy can demand for poll. At the time of demand, they shall possess at least 1/10 of total voting power, or in terms of paid up share capital, at least 5 lakhs paid up share capital. Any condition if they satisfy, they can demand poll. So 1/10 of voting power or 5 lakh rupee paid up share capital, both are included. Other companies, that means company without share capital, just ignore second condition, only one condition, that is at least 1/10 of total voting power. At least 1/10 of total voting power. If they possess at least 1/10 of total voting power, then they can demand for poll. Circulation of members resolution. Requisition is valid if it is signed by members holding not less than 1/10 of paid up share capital as on date carries the right of voting. If it is a company without share capital, then members shall represent at least 1/10 of total voting power as on the date a right to vote. As on the date carries the right of voting. So here the applicable limit is 1/10 or more. 1/10 or more. Next, ordinary resolution. Simple. Votes in favor greater than votes against. Ordinary resolution. Special resolution. Votes in favor greater than or equal to 3 times of votes against. Special resolution. So equality is possible in special resolution. Suppose votes in favor equal to 3 times of votes against. Yes, we get special resolution. But if votes in favor equal to votes against, it is not it should not be considered as ordinary resolution. Are you getting my point? Equality possible in special resolution. Votes in favor equal to 3 times of votes against. Whereas ordinary resolution, votes in favor equal to votes against, you can't declare it as ordinary resolution. In such cases, chairman of the meeting will be given a casting vote right, additional vote right. So he will declare whether resolution to be passed or not to be passed. Understood? So votes in favor equal to votes against, not ordinary resolution. Votes in favor equal to 3 times of votes against, special resolution. Special notice. Generally, company can give notice of general meeting at least 21 days before meeting. But special notice, members will give special notice to the company at least 14 days before date of meeting. It should not be earlier than 3 months, but it should be at least 14 days before the date of meeting. So 14 days before the date of meeting, they can give special notice. Sir, it is 10 days before meeting, sir. They can't give special notice. And once company receives this special notice, company has to circulate special notice among the members at least 7 days before the meeting. At least 7 days before the meeting. So 21 clear days, 21 clear days is for notice. 14 clear days, 14 days before meeting. 14 days before meeting is for special notice. And 7 clear days is for circulation of special notice among the members. Next one, resolutions and agreements to be filed by the company. Now, whenever company passes a special resolution or whenever company enters into an agreement with a managing director, all these special resolutions and agreements with the directors, all these things shall be filed with the registrar. And what is the time limit, sir? Same time limit, 30 days of passing the resolution or 30 days of entering into the agreement. For IFSC companies, the time limit is 60 days. Next one, minutes. So what is the time limit for completion of minutes of the meeting, sir? 30 days of the meeting. In case of resolution passed by postal ballot, within 30 days of passing the resolution by postal ballot, minutes shall be completed. Minutes shall be finished. Next one, signing of minutes book. Okay, one note point is there. For IFSC companies, there is no time limit with respect to director meeting minutes, committee meetings, director meetings minutes and committee meeting minutes. There is no time limit for completion of those minutes. Next one, signing of minutes book. No time limit means what? Okay, wait. No time limits means what? Above 30 days time limit is not applicable to IFSC companies in case of board meetings, in case of committee meetings. The time limit is at or before the next board or committee meeting. The minutes shall be prepared and signed at or before the next, succeeding board meeting or succeeding committee meeting. Next one, signing of minutes book. Minutes related to general meeting, minutes related to postal ballot resolution. The minutes shall be signed within 30 days of the event. That means, within 30 days of general meeting or within 30 days of passing resolution in postal ballot, the company has to complete minutes. The company has to get signature from the chairman of the meeting. So chairman of the meeting should sign the minutes within the same time limit. See, once again I am telling you, this is not 30 plus 30, this is single 30. So event finished this is a event date. Within 30 days, company has to maintain minutes and company has to get its minutes signed by the chairman. This condition is compulsory for general meeting minutes, members meeting minutes, postal ballot minutes. Understood? Coming to board minutes, coming to committee minutes, for signing there is no time limit. Maintenance of minutes is different, signing of minutes is different. For general meetings and then members meetings, postal ballot, signing and maintenance both have only one time limit, that is 30 days of event. Coming to the board meetings, committee meetings, maintenance of minutes is 30 days, signing there is no time limit. Next one, holding of AGM. This is very simple provision. Every year company has to conduct one AGM. First AGM, the first AGM shall be conducted within 9 months from the closure of first financial year. So first financial year closure date is 31st March 2023, sir. Add 9 months. So due date of first AGM is 31st December 2023. Next, subsequent annual general meetings should be held within 6 months from the closure of financial year. So closure of financial year date is 31st March 2024. Add 6 months. So 30th September 2024. And the gap between two AGM should not exceed 15 months. Previous AGM was conducted on 31st December. So to this add 15 months. It will be 31st March 2025. So out of these two limits, whichever is earlier means 30th September 2024. So first AGM time limit is 9 months from closure of first financial year. Subsequent AGM we had two limits. One is within 6 months from the closure of financial year, and time gap between two AGM shall not exceed 15 months. Out of these two, whichever is earlier, consider the date as due date of AGM. And every year company has to conduct one AGM. Okay. Next one, extension of date of AGM is possible only for subsequent AGMs but not for first AGM. For first AGM there will be no extension. We have given already sufficient time, so no extra time. Coming to subsequent AGMs, yes, 3 months extension is possible and ROC is having power to extend subsequent AGMs by 3 months. Next one, AGM on requisition. See, some members can demand company for calling AGM. Suppose members demanded company to call for AGM. Within 21 days, day one, company received a requisition. Within 21 days, company has to call for general meeting. Company has to make all the arrangements for calling a meeting. And within 45 days, that meeting shall be concluded. So the meeting shall be concluded within 45 days from the date of receipt of requisition. So within 21 days, company has to make all arrangements for calling general meeting, and within 45 days of date of receipt of requisition, meeting shall be conducted, meeting shall be concluded. Suppose company fails to call for meeting within 21 days, company fails to conduct meeting within 45 days. In that case, power to call for meeting, power to conduct meeting shall be transferred to requisitionist. Requisitionist can conduct meeting within a period of 3 months from date of requisition. 3 months from date of requisition. Next one, all listed public companies shall file a report on AGM with ROC in form MGT 15 within 30 days of AGM. Report on AGM is applicable only to the listed public companies, and the time limit is 30 days of AGM. Within 30 days of AGM, they need to file MGT 15 with ROC. Next one, dividends. There is a interconnection between these 5 time limits. So let me explain you in the chart. Date of declaration. From date of declaration, within 5 days transfer dividend amount to separate bank account. Next, within 30 days of date of declaration, distribute dividends among members of the company. Distribute or payment, whatever it may be, distribute or payment. Next, from here onwards, just observe carefully. After completion of 30 days, any dividend which is unpaid or unclaimed, transfer to unpaid dividend account. Sir, what is the time limit, sir? The time limit is within 7 days after completion of 30 days. Within 7 days. I forgot to tell you, this 30 is inclusive of 5. Just observe it carefully. Next one, sir, transfer completed. Now, from the date of transfer onwards, within 90 days, prepare a statement containing particulars of the members. Statement of members who didn't claim their dividends or whose dividends remains unpaid. Within 90 days from date of transfer to unpaid dividend account, prepare a statement, publish it in the website. Next, from transfer to the unpaid dividend accounts, after expiry of 7 years, any amount which was not claimed within 7 years from date of transfer to unpaid dividend account, those amounts shall be transferred to IEPF account. Understood? So the limits are very simple. Just small confusion, but very simple. Within 5 days of declaration, transfer to separate bank account. Within 30 days of declaration, distribute entire dividends among the members. If any amount remains unpaid or unclaimed, transfer to unpaid dividend account within 7 days after expiry of 30 days from date of declaration. Once you transfer amount to unpaid dividend account, within 90 days, prepare a statement of members, particulars of the members whose dividend remains unpaid or unclaimed. And once after completion of 7 years, from the date of transfer of amounts to unpaid dividend account, transfer to IEPF account, which remains unpaid or unclaimed for 7 years. So everything I discussed. Next one, dividend out of free reserves. Current year profits are not adequate. In that case, company can declare dividends out of free reserves. In that case, the dividend rate shall be less than or equal to average of last 3 years dividend rates. Last 3 years company didn't pay any dividend, then this condition is not applicable. Maximum withdrawable amount from the reserves is 10% of paid up share capital plus free reserves. And after withdrawal, the balance in free reserves shall be minimum 15% of paid up share capital. After, you can withdraw up to 10% of paid up share capital plus free reserves. But after withdrawal, the balance in free reserves shall be minimum 15% of paid up share capital. Satisfying these conditions, you can withdraw amount from free reserves. Next, accounts of companies. Companies are required to file periodical financial results with registrar within a period of 30 days of completion of relevant period. Prescribed companies have to file periodical financial results. The time period is 30 days of completion of relevant period. Reopening of books of accounts is possible only with respect to 8 preceding financial years, not more than 8 preceding financial years. So in the current financial year, we are in the current financial year 2024-25. Last 8 financial years books of accounts can be reopened. Next, if company wants to revise its financial statements or board report voluntarily, then that revision is permitted for the financial statements related to preceding 3 financial years only. So that voluntary revision is permitted only for the financial statements of 3 preceding financial years. Applicability of CSR. CSR is applicable to all the companies which is having a net worth of 500 crores or more, which is having a turnover of 1000 crores or more, which is having a net profit of 5 crores or more. Any one condition satisfied, then it is required to have CSR committee. First, it is required to constitute a CSR committee, then it should comply the provisions of section 135. Of course, if the amount of CSR to be spent by the company, if it is less than or equal to 50 lakhs, then CSR committee is not required. Board of directors are sufficient to execute the CSR policies and to implement CSR policies. That's it. Understood? See, once you are covered under this section, then at least 2% of average net profits of the company you should spend on CSR, on corporate social responsibility. If the 2% of average net profits is just 50 lakhs, then no need to have CSR committee. Sir, exceeding 50 lakhs, sir, suppose 50 lakhs 1 rupee, sir, 50 lakh 1 rupee, then company shall constitute CSR committee. CSR committee is responsible for framing, monitoring, recommending CSR policies. Next one, out of this CSR amount, you can spend, company can spend up to 5% on administrative overheads. Salaries to the workers in that CSR, regarding CSR. So whether CSR policies were were implemented properly or not, for that, you hired a manager. Now you can pay salary to the manager. Maximum administrative overheads with respect to CSR shall not exceed 5%. Maximum 5% of CSR amount only. Next one, projects are of two types. CSR projects are of two types. One is ongoing project and the other one is other than ongoing project. You selected other than ongoing project, and the amount, amount that you are required to spend on CSR is, for example, 1 crore. Amount kept aside for CSR is 1 crore. Out of 1 crore, you spent 80 lakhs and 20 lakhs remain unspent. Now, the 20 lakh rupees amount, you need to transfer that amount to a fund specified in Schedule 7 within a period of 6 months of expiry of financial year. In the current year, you are supposed to spend 1 crore rupees on CSR, but you spent only 80 lakhs. And you are not, you didn't selected ongoing project. An ongoing project which will, which you need to spend money over a period of time more than, 1 year. So, for example, 3 years, 4 years, 5 years projects, ongoing projects. Are you getting my point, students? So, other than ongoing project, 1 year project only, within 1 year only. In that case, any amount which you didn't spend, transfer that amount to a fund specified in Schedule 7 within a period of 6 months. If it is an ongoing project, no problem. Within 30 days from end of financial year, transfer amount to unspent CSR account, like unpaid dividend account, open unspent CSR account. Transfer unspent CSR amount to CSR account, unspent CSR account, and utilize this amount within 3 financial years. If you fail to spend this amount within 3 years, then transfer all the amounts, transfer the amount which is lying in unspent CSR account to a fund specified in Schedule 7 within a period of 30 days from completion of 3rd financial year. Are you all getting my point, students? Next one, a copy of financial statements including consolidated financial statement, audit report and other documents which are to be laid before general meeting, which are to be laid in the general meeting, shall be circulated among the members of the company, shall be given to every trustee of the debenture holders, every trustee of the debenture holder, every trustee of the debentures, simply debenture trustee. So what is the time period for circulating these financial statements, sir? The time period is before 21 days before the date of meeting. At least 21 days before the date of meeting, similar to the notice only. Notice, 21 clear days, right? So here, 21 days before the date of meeting, you should send a copy of financial statements, audit report, board report to every member of the company, to every debenture trustee. For Section 8 company, time period is 14 days. Sir, shorter notice possible? Yes, possible, but with consent of the members. Consent of the members, you can give copies of financial statements for a period less than 21 days. And how much consent I should get, sir? What is the percentage? Consent of majority in number entitled to vote and who represent not less than 95% of such part of paid up share capital of the company as gives a right to vote at the meeting. So 2 conditions. One is majority of members representing at least 95% of part of paid up share capital. If these two conditions are satisfied, then company can give copy of financial statements to the member even less than 21 days before the meeting. In case of company without share capital, consent of not less than 95% of total voting power exercisable at the meeting. Next one, XBRL filing. XBRL, extensible business reporting language. This is applicable only to few companies. So what are those companies? Listed companies and their Indian subsidiaries. Companies with paid up share capital 5 crores or more. Companies with turnover 100 crores or more. And companies which are required to prepare financial statements in accordance with Indian accounting standards, Ind AS. So these companies compulsorily should opt XBRL filing for filing its financial statements with ROC. Once covered, always covered. Once XBRL is applicable, then it is always applicable even in respect of all subsequent years, even when you come below these limits. Suppose 1 year my turnover is 110 crores. That's it. I should file financial statements using XBRL filing only. Sir, immediately the next year my turnover fall into 80 crores, sir. 60 crores, sir. 5 crores, sir. No problem. You just go with XBRL format only. Next one. Annual returns, financial statements, filing financial statements by OPC as well as other than OPC. Every company except OPC shall file financial statements with registrar within 30 days of AGM. For annual returns, 60 days of AGM, right? 60 days of AGM. Whereas financial statements, 30 days of AGM. With respect to OPC, AGM is not mandatory, right? So OPCs are required to file financial statements with registrar within 180 days from closure of financial year. 180 days from closure of financial year. Next one, applicability of internal audit. All these 7 companies must have internal audit function. What are those companies? Listed companies, unlisted public companies, yes, 4, private companies, 2 categories. 4 unlisted public companies you can find. One is paid up share capital 50 crores, turnover 200 crores, outstanding borrowings 100 crores, outstanding deposits 50 crores. Next, private company, turnover 200 crores, outstanding borrowings 100 crores. And clearly observe the star marks. Wherever I kept star marks, here the point is you need to check these amounts at any point during the preceding financial year. In one attempt, a question was asked for 5 marks. In that question, yes, the point is paid up share capital is it is 10 crores, no problem. Turnover, it is 150 crores, no problem. Internal audit is not applicable. Outstanding borrowings as on 1st March 2024 is 110 crores and as on 31st March 2024 is 50 crores. Now they asked a question whether internal audit is mandatory or not mandatory. So many students, what they think, they will check 31st March 2024 balances and they will come to a conclusion internal audit is not applicable, but it is a wrong answer. So, with respect to loans, with respect to deposits, you need to check at any point of time during the immediately preceding financial year. So at one point of time, yes, outstanding borrowings, it exceeded the limit of 100 crores. Therefore, internal audit is compulsory to that year, to that financial year. Next one, audit and auditors. Audit and auditors, audit committee. Audit committee is applicable to all the listed public companies without any limits. And to those public companies, which is having a paid up share capital 10 crores or more, turnover 100 crores or more, outstanding borrowings, debentures, deposits 50 crores or more. So this is regarding applicability of audit committee. Public company with any of these conditions satisfied, shall have audit committee. Listed public companies, forget about the limits, compulsory, mandatory audit committee. Next one, rotation of auditors. Rotation of auditors is applicable only to the listed companies and it is applicable to all the companies excluding OPCs and small companies. With respect to unlisted public companies, paid up share capital 10 crores, private limited companies, paid up share capital 50 crores, unlisted public company or private limited company, outstanding borrowings, if they are 50 crores or more, then also rotation of auditors is compulsory. So this third point is applicable to both unlisted public company as well as private company. Getting it? Next one, appointment of auditors. So time limit for appointment of auditors. In case of government company, first auditor, C&AG shall appoint within 60 days of incorporation. Failed. Then board of directors in the next 30 days. Failed. Then members within next 60 days. Coming to non-government company, board of directors shall appoint first auditor within 30 days of incorporation. Failed. Then members shall appoint first auditor within 90 days. Subsequent auditor, in case of government company, C&AG shall appoint within 180 days of commencement of financial year. In case of non-government company, in AGM, appointment of subsequent auditor will take place. In case of casual vacancy, C&AG shall appoint auditor to fill the casual vacancy within 30 days of vacancy. Failed. Then board of directors within next 30 days. Coming to non-government company, board of directors shall fill the casual vacancy within 30 days of vacancy. But if that vacancy is arising due to resignation, in that case, appointment, board resolution alone is not sufficient. Ratification, approval from members is also required. And for getting that approval, you are having a time period of 3 months. So within 3 months of recommendation of the board, your company is required to get approval from the members. Next one, removal of auditor before his term. This point was also tested in previous examination, I think for 4 marks. See, for removal of auditor, 3 compulsory conditions you need to satisfy. First, board resolution. Once board resolution is passed, within 30 days, file an application with CG. Once you receive CG approval, then within 60 days from CG approval, obtain special resolution at general meeting. So time limits here 30, 60. 30 for filing an application with central government. Within 30 days of board resolution, file application with central government. In case of IFSC companies, it is 60 days. Okay. Once company receives approval from central government, then within 60 days, company should pass a special resolution. Then only removal is valid. If any one condition is failed, then removal is invalid. Next one, resignation by auditor. Auditor can resign. Auditor can come out of audit office. But the point is, within 30 days of resignation, he has to communicate the matter with ROC, company and C&AG in case of central government, in case of government companies. So time period for filing resignation statement is 30 days from the date of resignation. Next, even in disqualifications also we are having a time limits. Disqualification with respect to holding of securities. A relative can hold securities up to face value of 1 lakh. Up to. That means 1 lakh is also covered. Even if you hold 1 lakh face value of securities, no disqualification. Understood? Next one, direct indebtedness. You are liable to the company, a subsidiary, holding, associate, subsidiary of holding. If your indebtedness is more than 5 lakhs, then disqualified. Sir, exact 5 lakhs, sir, then no disqualification. Next one, indirect indebtedness. That means, you gave a guarantee. So guarantee amount is greater than 1 lakh, sir. Then disqualified. Sir, it is just 1 lakh only, sir. In that case, no disqualification. So here, equal to is very, very important. Equal to 1 lakh, no disqualification. Greater than 1 lakh, disqualification. Equal to 5 lakhs, no disqualification. Greater than 5 lakhs, disqualification. Very, very important. Next one, you can act as an auditor maximum 20 companies. You cannot be appointed as an auditor for more than 20 companies. So up to 20 companies, no disqualification. Next one, a person who has been convicted by a court of an offence involving fraud and a period of 10 years has not elapsed from the date of such conviction. So yes, you were declared, you committed one fraud and you have been sentenced to jail. In that case, 10 years should be completed from the date of such conviction. Up to 10 years, you are disqualified. Next one, reporting of frauds. Reporting of frauds. If fraud amount is equal to 1 crore, then communicate with central government. If it is less than 1 crore, communicate with board of directors or communicate with audit committee if audit committee is there. Understood? Equal to 1 crore, central government. Less than 1 crore, board of directors or audit committee. C&AG is having a power to conduct a supplementary audit, but he can exercise this power within 60 days from date of receipt of audit report from the auditor of government company. So within 60 days he can exercise the right of supplementary audit. Next one, company shall appoint cost auditor within a period of 180 days from commencement of financial year. Once appointment of cost auditor happens, the same shall be communicated with central government within 30 days of the appointment or within a period of 180 days from commencement of financial year, whichever is earlier. Whichever is earlier. Suppose appointment happens in the month of July. So within 30 days means in August you communicate with the central government. Company communicate about appointment of cost auditor with central government. But the deadliest time limit is within 180 days you have to appoint cost auditor, and within the same 180 days you have to communicate with the central government regarding appointment of cost auditor. So cost auditor once appointed, he should submit a signed report within a period of 180 days from the closure of financial year. So within 180 days from closure of financial year, he is required to submit cost audit report. Next one, applicability for maintenance of cost records. Another tricky area. Tricky area. See, not all companies are required to maintain cost records. Only companies which are engaged in providing services or production of goods listed in table A or table B. That means it must manufacture goods which are covered in either table A or table B, or it must provide services which are categorized in table A or table B. Suppose I'm producing goods which are not covered in table A, which are not covered in table B. In that case, I'm not required to maintain cost records. First, you should produce a table A product or table B product. Next condition, your overall turnover is equal to 35 crores or greater than 35 crores. Then you are required to maintain cost records. Sir, this condition I didn't satisfy, sir. Then cost records are not mandatory to you. You are not required to maintain cost records. Clear? So compulsorily you are engaged in production of goods or providing services which were listed in either table A or table B, and your overall turnover should be 35 crores or more in the immediately preceding financial year. Next, applicability of cost audit. Cost audit is applicable to the goods listed in table A only if overall turnover is greater than or equal to 50 crores and table A, table B turnover is 25 crores. Table A, table B turnover is 25 crores. In that case, cost audit is applicable to the products listed in table A. Suppose my overall turnover is 100 crores or more, and my turnover from table A, table B products is 35 crores or more. In that case, cost audit is applicable to both A as well as B. Cost audit is applicable to the products listed in table A as well as listed in table B. Understood? So understanding these limits is very, very important. Very, very important. Detailed explanation with respect to applicability of cost audit, I did it in marathon, and that marathon is already available in YouTube. Since I'm revising the limits, I'm just telling you the limits. Overall turnover 50 crores. Turnover from table A, table B products 25 crores. Then cost audit is applicable to products listed in table A. Overall turnover 100 crores. Turnover from list A products, table B products is 35 crores. Then cost audit is mandatory for the products listed in table A as well as table B. Next, companies incorporated outside India. Deemed Indian company. Indian citizens. Indian companies or body corporates incorporated in India, or Indian citizens and one or more companies or body corporates incorporated in India. All these people put together hold 50% of paid up share capital. Not less than means greater than or equal to 50% of paid up share capital. It may be equity or it may be preference or it may be both equity and preference. If they are holding this much of paid up share capital in a company incorporated outside India, for example, C Incorporation, which was incorporated in USA, and this C Incorporation started a branch office in India. In that case, this branch office, this company is required to comply all the provisions of Companies Act as if it is an Indian company. Here the applicable limit is 50% of paid up share capital or more than 50% of paid up share capital. And then every foreign company within 30 days of establishment of its place of business in India deliver to registrar for registration of place of establishment in India. So the time limit is 30 days of establishment. It is required to file documents with a registrar. Next one. Any alteration in the above documents shall be communicated with a registrar within the same time period of 30 days only. So within 30 days of establishment, communicate with registrar. Within 30 days of alteration of aforesaid documents, again communicate with registrar. The time limit is 30 days only. Next one, financial statements of foreign companies shall be delivered to registrar within a period of 6 months of the closure of financial year of the foreign company. Generally, 30 days from AGM. Domestic companies, 30 days of conclusion of AGM, it is required to file financial statements with ROC. Whereas foreign companies, the time period is 6 months of the closure of financial year. Next one, every foreign company shall file an annual return in form FC4 along with prescribed fees within a period of 60 days from the last date of the financial year to the registrar. Coming to domestic companies, the time limit is 60 days of conclusion of AGM. When AGM is concluded, to that add 60 days. You will find due date for filing annual returns. Coming to foreign companies, here AGM is not the point. Here the point is last date of the financial year. To that add 60 days. And that is the due date for filing annual returns. And the last chapter, limited liability partnership. Last topic, limited liability partnership. So small LLP, important definition. So LLP with a contribution up to 25 lakhs and a turnover up to 40 lakhs will be categorized as small LLP. Next one, LLP, the name reservation period is 3 months. For companies, name reservation period is 20 days. Coming to the LLP, the name is reserved for a period of 3 months from approval. Next one, in case of infringement of trademark, same time period Just now I discussed with you in incorporation of companies. Yes, the owner of registered trademark has to file an application with central government within 3 years of incorporation of the company. Here also the same time limit. Next, whenever LLP changes its name or obtains a new name, it is required to give a notice to the registrar within 15 days from date of change. Within 15 days from date of change of the name, it has to give notice to the registrar along with the order of central government. This is all about rectification of name. Already discussed with you in companies chapter, in incorporation of company chapter. So rectification of name, same time limits. There is no change in time limit. There also you can see 15 days time limit. Here also 15 days time limit is there. Understood? But additional time limit is, within 30 days of change, you need to amend the LLP agreement. Nothing but LLP deed, partnership deed. You will find partnership deed in case of general partnership forms. Here it is LLP agreement. A person may cease to be a partner of LLP in accordance with an agreement. However, he should give his intention of resignation to the LLP not less than 30 days. So here notice is compulsory. That notice is not less than, that notice shall be given not less than 30 days of his intention to resign as the partner to all other partners. Time period is not less than 30 days. Next one, every partner shall inform the LLP regarding change of his name or address. Suppose, I'm a partner in LLP. Very recently I changed my address. Now within 15 days of change of address, I need to communicate with LLP. LLP will communicate with ROC. So my duty, within 15 days of change, I should communicate with LLP. LLP shall communicate the same with registrar within 30 days of such change. So that means, 15 days of change, 15 days of change, 30 days of change. 15 days of change, partner has to give notice to LLP. 30 days of change, LLP has to give notice to the ROC, registrar. Understood? Next one, about resignation, LLP, if a person ceases to be a partner or files a notice with registrar within 30 days from the date he becomes or ceases to be a partner. Whenever, partner is coming out of LLP, so LLP has to LLP has to intimate a registrar within 30 days of resignation by the partner. Next one, statement of account and solvency. In companies we call financial statements. Here we call it as statement of account and solvency. Statement of account and solvency shall be prepared within 6 months from the end of each financial year. Understood? So statement of account and solvency shall be prepared within 60 days from the end of financial year. And LLP shall file an annual return with a registrar within 60 days of closure of its financial year. Within 60 days of closure of financial year, LLP has to file annual returns with registrar. Company, 60 days of AGM. LLP 60 days of closure of financial year. Statement of account and solvency, preparation 6 months. Filing, you will be given 30 days time period. 30 days time period. So closure of financial year, add 6 months. This 6 months is for preparation of statement of account and solvency. To that add 30 days, then you will get a due date for filing statement of account and solvency with ROC. Due date for filing statement of account and solvency. Next one, compounding of offenses. So once you claim benefit of compounding of offenses, you can't claim the same benefit for same offense for the next 3 years. Once you got the benefit of compounding of offense, for one offense, you claimed compounding. Next 3 years, you can't claim same benefit with respect to same offense. So 3 years ban period. And next, whenever offenses get compounded, then you have to communicate the same with the registrar, intimate the registrar within a period of 7 days from date on which offense is so compounded. And next one, designated partners. Every LLP shall have at least 2 designated partners. Out of 2 designated partners, one shall be a resident in India. One shall be resident in India. So here residential status, how can we check residential status? Period of stay in the preceding financial year. If it is greater than or equal to 120 days, then we can call him as resident. So every LLP shall have 2 designated partners. Compulsory these 2 designated partners should be individuals. Out of 2 designated partners, one should be resident in India. So with this, various limits in corporate laws is completed. I hope this lecture is helpful to you. So I'll upload this document along with the video lecture. Clear?